Claimant Investment Authority.
Mr. Wordsworth.
May it please the Court, I act with Mr. Dar and Mr. Webster for the Republic of India, my learned friends Mr. Otti and Mr. Chiratovitz, and also Mr. Tompkins act for the Ras Al Khaimah Investment Authority, that is RAKIA.
Yes.
You should have received skeleton arguments from both parties.
Yes, thank you.
An additional skeleton from India. My Lords, you will have seen this a floating issue before you as to when best to deal with the Respondent's ground 3. I don't know if you've had a chance.
We have discussed that, and we think that the best way to deal with that is for Mr. Otti to deal with that at the end of his submissions, and then I think he needs permission to raise that, and we'll see where we go at that point.
Thank you very much, my Lord. So the basic facts are summarised at our skeleton paragraph 5, which is at core 3, page 19, are that RAKIA was involved in a project to build and operate an alumina plant and smelter in Andhra Pradesh, and it put in capital of 42.5 million and thereby owned at all the relevant times a shareholding of approximately 12% in the local Indian company ANRAK. And of course it's ANRAK that was to build and operate the plant. The refinery was built largely with money borrowed from Indian banks. It was to be supplied with bauxite under a bauxite supply agreement, importantly between ANRAK and the state-owned mining company called APMDC. Following significant unrest in the mining area, the government of Andhra Pradesh cancelled the governmental order giving permission for conclusion of the bauxite supply agreement, the BSA, which was subsequently terminated by APMDC. So far as concerns the background procedural history, there was full debate on jurisdiction and the merits before the tribunal presided over by Lord Hoffman, and this unanimously found that it lacked jurisdiction. The awards at supplemental volume tab 1, I'll come back to that at relevant junctures. That award was set aside by Mr. Justice Robin Knowles, and the current appeal solely concerns jurisdiction of the arbitral tribunal.
Yes.
The key issue is whether there is a measure which is a jurisdictional requirement for there to be an offer to arbitrate under Article 10 of the treaty. That is what the tribunal found unanimously. The reference for that is award paras 82 through to 110 at supplemental bundle 20 through to 32. And RAKIA's section 67 challenge to the finding on that was dropped shortly before the hearing before Knowles J, as you've already seen. Just so you can see the key provision in India's appeal, that is the definition of a measure, if I can ask you to turn to core tab 14, and here you see the BIT, and in due course obviously I'll be spending some time on the definition section looking at the meaning of investment, which is a big issue. But over at page 140, article 1.8, measure means any form of binding action taken by a contracting party under any law, rule or regulation and applied directly to an investment. Now, that matters for jurisdictional purposes, particularly because of Article 10.2, which you can see at page 148 in this tab. Just starting with 10.1, you can see an introductory provision: disputes arising between a contracting party and an investor of the other contracting party in respect of an investment under this agreement shall be governed by this article. That's a form of introductory provision. But then at 10.2, in the context of the Republic of India, this article shall cover measures, as defined, of course, in Article 1.8, as I've just seen you, underlying a dispute taken by the central government and or the state governments while exercising their executive powers. It's just about exercise of executive powers in accordance with the Constitution of India. So, as the tribunal found, Article 10.2 imposed a very important jurisdictional requirement that there be a measure. And perhaps just while we're here, my lords, if I could ask you just to turn over to 10.8b, page 150. And this is the strongest possible confirmation that measure is indeed a jurisdictional requirement, because you can see from the limitation provision, 10.8b, if more than 5 years have elapsed from the date on which the investor first acquired or ought to have acquired with reasonable diligence knowledge of the measure underlying the dispute, and that the knowledge had incurred substantial loss or damage as a result of such measure. So limitation turns on knowledge of the measure, confirms, as I say, strongly that 10.2 is a jurisdictional requirement. Now, with your
You emphasised executive powers.
Yes, my lord.
Does that mean that on your case, if, for example, legislation had been passed confiscating the shares, there would be no jurisdiction to do anything about that?
Absolutely, yes, my lord. This is a restriction of jurisdiction. And as one commonly sees in BITs, jurisdiction is restricted in various ways. The situation is not, for example, like in domestic law, where one might always think, well, where there is a right, there is a remedy. When it comes to international law, as my lordships know, the default position is that there is no consent to jurisdiction. And there's nothing unusual at all about a treaty such as this confining jurisdiction to very specific matters. Here, measures as defined, and only executive measures.
Yes. I mean, that particular point, I think, is not a problem in this case, because the measure which is relied on was done in the exercise of executive powers, although we have all the questions about applied directly.
That's absolutely correct, my lord. So that's not an additional point. But perhaps just to make good the point that I was just referring to, that one should not be looking at this treaty as if one should expect jurisdiction to follow substantive protection. Could we possibly go to the EAIB case, which RAKIA relies on quite heavily in its skeleton, at Authorities Volume 1, tab 12. And this is a tribunal presided over by Professor Sir Christopher Greenwood, who I suspect is a name known to the members of this court, obviously formerly a judge of the International Court of Justice. If I could take you to page 175 in this tab. And you can see here at paragraph 385, what the tribunal is dealing with is an argument on object and purpose. It's an argument that the RAKIA makes in this case, which is, well, the object and purpose is to protect, and that must require arbitral protection. If I can take you from about halfway down, in particular, the tribunal cannot accept what appears to be the premise of the claimant's argument, namely that treaty provisions laying down standards of substantive treatment for an investor must be deemed ineffective if they are not enforceable through arbitration. It may well be the case that such provisions are more effective if they are enforceable in that way, but the state's parties to the present BIT clearly decided that, subject to the later discussion of the MFN clause, they would adopt several substantive standards, such as the requirement of fair and equitable treatment in Article 2, which would not be enforceable through arbitration. There are numerous other BITs in which the same choice has been made, and one state, which is both a major recipient of foreign investor and the state of a nationality of some important investors, namely Australia, has recently announced that its policy will not be to include any investor-state arbitration provisions in its future BIT. And the tribunal then goes on to consider various cases where there have been restrictions to jurisdiction. Very commonly, that is with respect to just the amount of payment arising out of an expropriation. So in fact, rather more narrow than in this case. A similar point is made, there's no need to take you to it, in the case of Incesa and El Salvador, which is at Authorities 18, page 255, at para 184. So, my lords, with your leave, we propose to deal with the issues in the following order. First, to look briefly at the judgment to identify the key facts and also to identify where India says the judge erred. Second, I will be focusing on ground one of the appeal, dealing with the term investment, and will set out India's consistent position that RAKIA's only qualifying investment in this case is its approximately 12% shareholding in the local Indian company ANRAK. Just for your note, that was RAKIA's initial position in its statement of claim, and the reference for that is paragraphs 173 to 180 of its statement of claim at supplemental tab 20, page 340. Of course, its position has changed in various ways since then, and as currently put, its investment includes all the project assets of ANRAK, that's the company in which it has this 12% shareholding, including the rights and obligations under the bauxite supply agreement, to which ANRAK, but not RAKIA, is a party. That's paragraph 31 of its skeleton. Now, just so you can see the bauxite supply agreement, that is in a supplementary bundle at tab 9. And you can see page 213, bauxite supply agreement between the Andhra Pradesh Mineral Development Corporation Limited, APMDC, which is the seller, and ANRAK Aluminium Ltd, which you can see overneath is the purchaser. And in a sense, the key obligation under this agreement is at clause 7, which is at page 223 of this bundle. The seller agrees and undertakes to sell and deliver to the purchaser exclusively in a continuous and uninterrupted manner, and the purchaser agrees and undertakes to purchase, accept and pay for the bauxite. And RAKIA's case before you is that that contractual right is an asset invested by it, even though plainly it is not a party to this agreement, and even though plainly, as a matter of the law governing this agreement, which is Indian law, it has no rights of any kind with respect to this agreement. It simply has a 12% shareholding in ANRAK. And as you'll see in a moment, it's critical because the judge's reasoning turns on the relevant governmental order, which it says was the measure, which the court says was the measure, that's GOM 44. It says GOM 44 was applied to the BSA, in effect. I'll show you the relevant paragraph in a second. So GOM 44 is the measure because that is the measure directly applied to RAKIA's investment. We say, well, that cannot possibly be right because the rights under the BSA cannot be RAKIA's investment. Now, as you've seen, Article 1.8 includes two elements. Measures means any form of binding action taken by a contracting party under any law, rule or regulation and applied directly to the investment. So I will be focusing on what is the investment in this case. Mr. Dar will then be focusing on our ground 2, which is that there was no relevant measure in this case, i.e. no binding action taken under any law, rule or regulation that was applied directly to the investment as correctly identified, i.e. there was no binding action on RAKIA's actual investment, which is its 12% shareholding in ANRAK, the local project company. We also have a discrete factual appeal, which Mr. Dar will also be addressing, because you'll see that the judge found, or appears to have found, that through the relevant governmental order, that's GOM 44, the government of Andhra Pradesh acted to end the establishment of the alumina and aluminium industry in Andhra Pradesh, and we say that that's just factually incorrect. My Lords, if I can then take you to the judgment, and starting with the facts as summarised in the judgment, and the judgment at core 9. If I can ask you to turn to para 105. And from paragraph 14, you can see that the judge is describing the memorandum of understanding that was entered into in 2007 by the government of Andhra Pradesh and the government of Ras Al Khaimah, and you can see under the first recital, state of Andhra Pradesh is having a rich bauxite deposit in 2 districts, and then a reference in the next recital to the fact that all these areas are falling under the reserve forest, as well as notified tribal areas, and the fact that they were in tribal areas and the impact of that and the local Naxalites' hostility to the project. That was a big issue on the merits. Then turning to paragraph 20, you can see the judge sets out further clauses from the MOU, in particular clause 2. The government of Ras Al Khaimah and its investment authority undertake to incorporate an Indian registered limited company, herein referred to as the said aluminium company, which will set up an alumina and aluminium refinery and smelter to produce 1 million tonnes of aluminium per annum initially, with expansion, and you can see there the anticipated capital outlay was about $2 billion. So that is the Indian company that was subsequently incorporated as ANRAK, and initially RAKIA had a 30% stake in ANRAK, but that was diluted and at all relevant times was a 12% or approximately 12% stake in ANRAK, which it had obtained through a capital outlay of $42.5 million.
And is it right to think then that what will give value to the shares in the Indian company which RAKIA is going to acquire will be its interest in the refinery and smelter which is going to be built, and the value of the supply of raw material which is dealt with in paragraph 3 of the MOU?
Well, in a sense, yes, my lord, but that we would say is not the relevant question. There's no issue here as to whether RAKIA acquired something of value. It did acquire something of value, but the thing that it acquired, the only thing that it owned or controlled, was the shares. So that's the critical point, and the point I'll come back to in a moment is that this treaty has what's called an asset-based definition, and it requires the identification of assets invested by the investor. The only asset invested by RAKIA was its shares.
Well, that doesn't make much sense, does it? The asset you may end up with is the shares, but you certainly don't invest shares. certainly in this case, they didn't invest shares.
My lord, it's certainly true that they put in cash in order to obtain shares. But when we look at the asset-based investment, you will see that the treaty is envisaging that the relevant asset is the asset that is acquired as a result of whatever contribution has been put in by the investor. I could go to that right away, my lord, or just run through the facts.
We see it from the treaty itself, don't we, that it talks about the initial capital investment.
My lord, if you go to
Page 146, isn't it?
tab 14, and rather than going straight to 146, which deals with transfer, protection of transfer, it's important to go to the definition of investment, and you see, for the purposes of this agreement, the term investment means every kind of asset invested by the investors of one contracting party in the territory of the other contracting party in accordance with the laws and regulations of the contracting party, in whose territory the investment is made, and in particular, though not exclusively, includes. And then you see there is a list of what the treaty parties consider to be assets invested by the investor. And then you see over leaf, one, movable and immovable property, as well as any other property rights in rem, such as mortgages, liens, pledges, or usufruct. And those are more naturally seen as the fruits of the investment, because of course you can't invest, for example, immovable property. Similarly, when one's looking at Roman 2, with shares, stocks, bonds, debentures, again, that is more obviously the fruits of the investment. You have acquired shares in the local Indian company. Then we look at Roman 3, which is particularly important in this case. And you see that the asset invested by the investor is rights or claims to money or to any performance under contract having financial or economic value. So 2 points here really. One, that is naturally what has been acquired as a result of putting cash in or whatever the contribution is. But two, it is showing that the asset invested by the investor is an actual right or claim to money. If one thinks of the BSA, RAKIA has no right or claim to money. The party with the relevant right or claim to money is the local company, ANRAK. So we say...
Well, it's the right or claim to performance, really, isn't it, rather than money, because
I
they're
apologise, my lord.
the
Yes.
buyer, so they're paying out,
Yeah.
but they're getting performance.
Yes.
But it's ANRAK who does it.
Yeah. But the point, of course, is the right to that performance is with the contract holder. So we say that these sub-articles show that what the treaty has in mind is that the asset invested by the investor is the fruits of the money put in, and then that is what the treaty then protects.
So you're not taking a narrow or literal view of invested by in the first line of Article 1.1, because it could be said that that's looking at what is put in, and all that RAKIA ever put in was the money, but you accept that what they got, the fruits of the investment, as you call it, was the shares, and you accept that that is an investment within this definition.
Precisely so, my lord. Precisely so. And that of course makes sense if you look at the treaty as a whole, because when you look at the protections, what is the treaty protecting? It's protecting the capital I investment in the substantive provisions. For example, you can see that Article 4 at page 141, and also it makes sense in the light of Article 1.8, the key provision in this case. You see measure means any form of binding action, etc., and apply directly to an investment. So that implies that the investment is something that is in existence and is something that is legally cognizable, as opposed to long since spent cash, which at the relevant time did not exist as a thing. It had been converted into shares.
So, for example, we can read Article 4.1, where it says investments by investors shall enjoy full protection, as meaning investments acquired by investors shall enjoy full protection.
My lord, yes.
Yes.
And we'd say that is the natural reading, investments by investors. And we'd say it's not a natural reading to say that a contractual right in which there is, which the investor has no legal rights or no ability to control, that is not a natural meaning of invested by an investor. My lord, if it's helpful just to go through a little bit more on the facts as set out in the judgment.
Yes, go ahead.
So going back to Core 9, at page 109, and you see there the judge is then setting out the terms of the BSA, and at paragraphs 35 and 36, making the point, of course, which is correct, that the BSA is entered into between APMDC and ANRAK Aluminium. He's mentioning also that clause 35 contained an exclusive jurisdiction clause in favour of the City Civil Courts of Hyderabad. Then moving on to paragraph 44 at page 112, you can see he starts summarising the project history, and then paragraph 51 at 114, as the tribunal summarised, a forest clearance was granted by India in August 2015. However, after a good deal of public protest, the government of Andhra Pradesh reversed itself, and on 22nd December 2015, the Chief Minister announced that he would cancel the project. Cancel the BSA. And then you see at 52, the measure in this particular case, that is GOM 44, the government of Andhra Pradesh issued an order number 44, GOM 44. This stated that the government hereby cancels GOM 222 and 289, in which the approval to the draft BSA was given. And then if I could ask you to turn to paragraph 100 at page 123. So this is to make the point that this is all, the judge's reasoning turns on GOM 44 as the relevant measure. And what is GOM 44 doing? The judge says at paragraph 100, for my part, I consider it clear enough that by GOM 44, the government of Andhra Pradesh was taking binding executive action to alter or end the BSA. So the point about GOM 44 is it is directed at the BSA, as the judge finds.
So the judge goes slightly further than the tribunal, who make the assumption, but for the judge, it's a finding.
That's absolutely correct, my lord. But the judge did not then say the BSA is an investment of RAKIA's, nor did the tribunal. And therefore, before this court, in its respondent's notice, RAKIA is seeking to uphold the judgment of Mr. Justice Robin Knowles by saying that the BSA formed part of its investment, even though it was not an asset of RAKIA's, and even though RAKIA does not control that asset. And if the BSA was not part of the investment, which of course is India's case, and that was the view of both the tribunal and the court, in order for the judge's decision on jurisdiction to be upheld, one would somehow have to conclude that GOM 44 was, as Article 1.8 requires, applied directly to RAKIA's investment, even though that investment did not comprise rights and obligations under the BSA. So, if I can then just outline our basic position on investment, and you've already seen, I think, some of this looking at the treaty. The BIT contains an asset-based definition of investment. So the investment must comprise identified assets invested by the investor, and the investment does not somehow extend to forms of rights and property owned by a third party in which the investor has a minority shareholding. The only asset invested by RAKIA, its investment in this case, was RAKIA's shares. RAKIA, of course, says that India is wrong. It accepts that there must be an asset, but it says that the words asset invested by do not connote ownership of the relevant asset or even control of the relevant asset. On its case, minority shareholding is absolutely sufficient, although I should point out that although there are now literally hundreds of cases on whether there is an investment for the purpose of an investment treaty, what is required for there to be investment, it does not point to a single case where a tribunal has found that the contractual rights of the local company form part of the investor's investment in analogous circumstances. That is, where the investor is a minority shareholder in the local company. Its case, which is at paragraph 15 of its skeleton, is that the words invested by are functional, signifying the use of assets to a particular end. So as we understand it, if RAKIA invests sums into a project to acquire shares, its investment comprises the assets of the local company because the investment comprises all the assets that can be seen as part of the wider investment project, even though RAKIA has no ownership or control over those assets, even though on the facts of this case, those assets were very largely acquired, i.e. the refinery was built, due to the money put in by Indian banks, not by reference to shareholder equity, although of course the majority shareholder, Appellant, did put in much more than RAKIA did by way of investment. So it seems to be seeing investment as a bit like mercury, sort of liquid mercury that somehow flows wherever the investment project happens to be, even though if you looked at a given asset, it's not only something it doesn't own or control, but at best, if you were somehow following the money, would have put in a tiny fraction of that relevant money, and some other legal person does have actual rights and control over that investment. Now, just so you can see what RAKIA was arguing before Mr. Justice Knowles, which was different. And if I could ask you to go to the judgment in Core 9 at from paragraph 89. So they see, as noted, RAKIA describes its investment as in the project as a whole, rather than a specific aspect of it, and refers to the operation of the overall project as well as its component parts. And what it's doing is applying a so-called holistic approach. Now, the holistic approach is an approach taken generally by ICSID tribunals, because Article 25 of the ICSID Convention does not contain a definition of investment. And where tribunals are applying a so-called holistic approach, they're saying, okay, you're saying your relevant asset is just a sale of goods contract. Now, sale of goods contract, pursuant to its natural meaning, is not an investment. But you have to look at the asset holistically, because it may be part of a much bigger picture. So if you look at that asset as part of the bigger picture, where, for example, you've got 10 sale of goods agreements and some long duration project that's all attached to this, then you could see that sale of goods contract, in fact, itself as an investment. Now, The judge at paragraph 90 says quite correctly, in my judgment, these descriptions provide a characterization that helps confirm that the assets invested by RAKIA were investments. They do not add to what the assets invested were. And you see there, RAKIA is building its case, or seeking to build its case, quite incorrectly, we would say, on something said by Mr. Justice Foxton, as he then was, in the Diag case, which of course is known to this court. Generally, I'm persuaded by the view that the issue of whether there is an investment should be looked at holistically, rather than by considering different components of an integrated activity in isolation, at least where the claim relates to that holistic investment. The judge continues, at least generally speaking, and Foxton J himself uses the word generally, I very much agree with the approach, but on my understanding, the importance of the reference to a holistic approach is to the issue of whether there is an investment. Whereas here a definition of investment is involved that is confined to assets, the holistic approach does not treat as an investment something that is not an asset. And you can see how there's a reference to the example given by then Mr. Justice Foxton, where the tribunal held that the offtake contract in issue in a given case was a contract for sale and delivery and not an investment, even if a holistic approach was adopted to the issue of whether there has been an investment. Now, the judge rejects quite correctly that holistic approach to the investment at this juncture, and says quite correctly that we're looking at an asset-based definition and you have to identify an asset. And as we understand it, this sort of holistic approach to the investment is no longer pursued by RAKIA in this case.
I'm not sure the judge does reject the holistic approach. I think he relies on it, but he says it doesn't take you beyond the asset.
My lord.
So I think the point he's making is, I mean, you can postulate a case where, I don't know, an extreme case where a day trader happens to buy some shares in a company which is a project company in India, but he's a day trader, he's only interested in the shares going up and down in value. That wouldn't be an investment, but it would nonetheless be an asset.
Yes.
And I think what he's saying here is that the nature of the shareholding here is a long-term one in a project company which was set up pursuant to all these agreements. And it helps to, in deciding whether it's an investment. But then he says, but you've got to go back and ask, well, what's the asset?
My lord, absolutely correct. What I should have said is the judge rejected RAKIA's case on a holistic approach, which was being used to expand the assets, i.e. the shareholding, into something much broader, that is the project as a whole. RAKIA's has changed its case, because its case is now the BSA is an asset invested by it. That wasn't its case before the judge. You can see that if we go back to paragraph 82 of the judgment, you can see its case there. RAKIA's investment was in the project as a whole, rather than a specific aspect of it. It included rights under the MOU, cash contributions of over 42.5 million, shares in ANRAK, the pledge of the shares, and its interest in the refinery and plant overall. it was expressly not saying that the BSA was an asset invested by it. That doesn't form part of its list of assets there, as you can see. And it's not coincidental. And just to, if I can give you 2 points to make, 2 references to make that point good, one can see paragraph 2 of their skeleton below. It's supplemental tab 26387, which refers to rights under the MOU, cash, shares, pledges, interest in the refinery and plant overall, but conspicuously does not refer to the BSA. And then also you can see the case as actually put orally. You can see that at tab 28, tab 27 in the transcript, at 391 of the bundle, where you can see Mr. Landau saying in terms, we have not listed the BSA in our list of assets.
Sorry, whereabouts on page 391 is that?
I do apologise, my lord. So the relevant passage picks up at the bottom of page 195. And there, Mr. Landau is referring to an argument that I was making, going through the approach of international law to the definition of asset and property law. Remember the Swissborough case, Court of Appeal in Singapore, and the point, which is correct, that as a matter of international law, if you want to understand the ownership of a property, the characteristics of that ownership, the scope of the ownership, you must look to national law. International law won't give you the answer to that. So if you want to ask the question, does somebody own a share and what would be the characteristics of that share? Let's say in India, you have got to look at Indian law. That's correct, and he spent a long time on that. But with respect, it's irrelevant here, irrelevant. We don't have a question here about the characteristics or scope of the ownership of assets and so on. He says that the court's being led astray, and then you see at the bottom, we have not listed the BSA in our list of assets. It's an absolutely conscious decision. We would respectfully say it was a legally well-founded decision not to put the rights under the BSA as being a form of asset invested by RAKIA. So then turning to the judge's reasoning on investment, just to show you some of the other passages apart from on holistic investment, this starts at page 120 of tab 9 at paragraph 77. And at paragraph 80, correctly, we say he identifies the question that lies ahead in the present case is whether measures were applied directly to the investment. For that reason, it will be important to establish not simply whether there was an investment, but the full extent of the assets invested. You can see in para 82, I've already taken you to that, what RAKIA's case then was.
That's the quote from the skeleton, is it?
I believe it is, my lord.
Thank you.
And then at 84 and 85, he asked the question, what did RAKIA invest and invest in the territory of the other contracting party that was an asset? We say that's the correct question. RAKIA did not invest rights under the MOU. That's the same conclusion as the tribunal. It did not have an interest in the refinery and plant that could be described as an asset. Its work as a sponsor and with Penna Cement was not an asset. The basic answer to the question is, in my judgment, it invested 42.5 million, the shares and the pledge of shares in the territory of Andhra Pradesh. Now, we've got a minor point on appeal as to his including the cash actually spent and the pledge, but that's not actually a fundamental to your reasoning, because the question is, whatever assets were identified by the judge, was the governmental order, the alleged measure, applied directly to those assets? And we say clearly the answer is no, even if one were to accept the cash and the long since spent cash as an investment, which we say is incorrect.
So it's right to say they invested the cash, but what they got for the cash was the shares, and there was never a stage when they had both the cash and the shares.
Absolutely right.
And therefore, for practical purposes, the investment that we're talking about there is the shares and not the cash. Now the judge goes on to say the pledge, not entirely sure how that would work, but does it matter whether he is right or wrong about whether the pledge is to be regarded as an investment? Because the same question about whether there is a measure which involves direct application would arise in relation, you say, to the shares, and whether we have to think about the pledge at all in applying that question doesn't seem to make much difference, as far as I can see.
Entirely correct with respect, my lord. And then, just so I can say it in two sentences, the point we're making about the pledge is this is a pledge given by RAKIA to a consortium of banks, Axis Bank. So we would not see that as an asset invested by it. We would see that as an asset of Axis Bank, as opposed to an asset of the
But there must be
shareholder.
But there must be a corresponding relationship between RAKIA and ANRAK by virtue of it giving that pledge.
Well, the pledge is with respect to its shares. So there's no question that it is a shareholder in ANRAK.
But if it pledges its assets in support of a loan to a third party, it must acquire rights against the third party, a right of subrogation at the very least, mustn't it, or a right to be indemnified. You don't give a pledge over your assets for a loan to a third party and get nothing back.
My lord,
It's foolish.
I would not be saying that there are no rights.
And those rights would be an asset, wouldn't they?
Well, the point,
Yeah.
the point is that what the treaty appears to be covering in the relevant provision is loans, debts, securities issued, and what it appears to have in mind there is where the investor has the benefit of the loan.
Yes, I understand that, and I think
security.
I think the pledge is not used in this way in the treaty when it's referred to pledge. But I don't accept, without more help, that in giving a pledge of its shares, which on the face of them may be worth 42 million, RAKIA was just giving away its asset.
Clearly not, my lord, because
No.
it still retained its shares.
No,
So-
but when it gives its pledge, in return for which money is advanced to ANRAK, it must have some rights against ANRAK in return. It's basic.
But it has rights. Its rights with vis-a-vis ANRAK are just rights as defined by having the shares and having the shareholders agreement.
Yes, but they have those before they give the pledge.
Yes,
But
the
somebody
pledge-
who gives security over their assets in favour of a third party is going to acquire rights against the debtor, if only by way of rights of any guarantor or surety has against the debtor, rights of indemnity, rights of subrogation.
But those rights in respect of RAKIA's shares. They're not rights in respect of, more generally, the project assets of...
No, they're right.
Of-
I don't think that's the argument here.
of
The
ANRAK.
question is just simply the question is do they acquire an asset? It seems to me they must acquire an asset.
My lord, can I return to that? Because
I'm not sure. I don't think it matters in any further sense than my lord has already identified. I just think, I mean, we haven't been told how this pledge worked. I don't think we've seen anything in relation to it. But the idea that RAKIA was just simply doing this out of the goodness of its heart and would not have any rights having given that pledge, basically they've given away the value of their shares on any other analysis.
my lord, if I may come back to it, because I agree with the point that my lordship is putting to me, that actually it makes no difference on the analysis.
I can see that.
Just one point on that. There does seem to be some reference to it in paragraph 46, I think, of the judgment. I don't know if there's a document which is... referred to. I don't think we've got that document.
I think not, my lord. And perhaps, you know, it's really for RAKIA to identify what rights it says it has under that pledge agreement, and then to identify those as an investment.
So if you think of the judge's trilogy of the cash, the shares and the pledge, the cash is something that is put in, the
Yes.
shares are something that is got out, is acquired, and one would think the pledge is something that is put in return for which they get something, whether it's rights under this agreement or rights at common law or whatever it may be, but you've got really to compare like with like.
My lord. Now, just going back to the judgment, I want to point out to you where we say respectfully that the judge erred. So you've already seen at 89 through to 94 that he's rejecting RAKIA's case on the holistic approach. So we say that when it came to identifying the investment for the purposes of Article 1.8, he referred to the investment as if it were the proposed establishment of the alumina industry as a whole. You can see that from paragraph 111. Where he says there was an application to the investment in that the action was applied to the proposed establishment of an alumina and aluminium industry in the state of Andhra Pradesh. So he's not saying there was application to the cash and shares and pledge because, and then identifying some legal link between GOM 44 and the cash, the shares and the pledge. He is, with respect we say, suddenly conflating the investment, which is a defined series of assets, with something which is not an asset. The proposed establishment of an alumina and aluminium industry in the state of Andhra Pradesh. And if one goes to, just looking at the preceding paragraph, India highlights the presence of two elements to the requirement that action is applied directly, that the binding action be applied to the capital I investment. So he's specifically asking the question, is the direct application to the investment, and that the application be direct. And yet in paragraph 111, he is in fact equating the capital I investment with something that is quite different, i.e. the proposed establishment, etc., which is not an investment. And we say what the judge should have been doing is asking in straightforward terms, was GOM 44, which I have identified as the potential relevant measure, was that applied directly to the shares cash pledge, which are the investment that I have just identified.
Can I just test out a little bit? I understand the focus on the asset, and there's no doubt that the asset held, let's ignore the pledge for the moment, the asset held is the shares. Let's imagine that an investor had just simply invested cash into the business in exchange for nothing more than a promise to repay the money. So its investment is literally cash sitting in the company's bank account. Would you say then that the investment is just simply the promise to repay?
Yes, my lord.
And if by government action the government comes along the very same day and seizes that 42 million cash, that's not action in relation to the investment, because it doesn't affect the debt. Debt's still there. So even though you put money in on the Monday and it's taken out by the government on the Monday afternoon, that isn't interfering with the investment. That's just simply taking the company's asset, namely the money in its bank account, and the investment is unaffected. That's what you say.
Well, I absolutely see the force of the question.
But that has to be the logic of your position, doesn't it?
I think the logic of my position is what is the relevant asset?
Yeah.
So, in that particular case, maybe I'm too hasty in saying the relevant asset is the contractual obligation to repay.
That's the only asset. That's the only asset that the investor has at that point.
Well, the cash in that particular situation might be seen as cash invested by the investor in return for the obligation to repay. So the cash in that case may well correctly be seen as part of the relevant asset invested. Do you see that?
The cash, no, forgive me. On your analysis, you look what is the asset of the investor. the asset of the investor is purely and simply the debt, the obligation of the company to repay. Whether that's written on a piece of paper or it's a debenture or some form of debt, all that the investor gets, it's not an uncommon form of investment. You invest money by way of debt. The money is sitting in the bank account waiting to be deployed on the developing the business of the company, but it's sitting in the bank account. Now, in common parlance, we would say, well, that money sitting there is the investment. But we're not talking about common parlance now. We're talking about this. And you're saying that the investment is not the company's asset, it's the investor's asset. And the investor's asset is simply the piece of paper that says, I, company, promise to repay you. That's your argument, is it?
My lord, yes, but on your example, I would say that the asset is still the cash, because there is the cash and promise to repay.
I don't understand that.
Because the cash is maybe I'm misunderstanding the cash has been loaned to the... Yeah. So
it's no longer the investor's money, it's the
I
company's
see,
money.
sorry, I didn't fully understand. So yes, the investment is the loan, that is the asset.
Yes. And so even the most incredibly direct intervention by executive action of the moment it's gone into the account, the government comes along and expropriates it, that is not directly implied to the investment because it isn't. It's applied to the company's cash, it's not applied to the loan.
My lord, I think in that question you're looking at more at the question of, in that context, what does directly applied to the investment mean?
Well, I think the two things they go together. And I think one of the problems, with your argument's approach here is that you're siloing these two issues. But at the end of the day, whether or not a measure is directly applied to an investment really has to be looked at as holistically, to use that term. And I think, and I understand why you do it. You say, well, we look very, very closely at what's an investment. It has to be an asset. And then we look at those very clear words applied directly to. And so we say, even if the government comes along and takes the cash which has just been invested, it isn't a measure which is directly applied to the investment because it isn't directly applied to the asset. Now, it's the overall conclusion we're ultimately ending up at. But I think there is an issue here about trying to define or relying upon the definition of investment so narrowly that you say, well, it's not the money that's put in or the business which is run with that money or the business of the company. It's just simply the debt, or if that debt is subsequently converted into equity, the equity. And it doesn't matter what the government does to the assets of the company, it can never be interfering, it can never be applying a measure directly to that investment unless it does something actually to the loan or actually to the shares. And that's the problem at the end of the day. I'm not sure it really matters at which stage the problem is exposed.
My lord, I fully see the force of your point. You're absolutely correct. We're trying to A, identify the investment, and B, see whether it's directly applied or not. We have on board very much your point that this is part of a sort of a global test as opposed to entirely discrete concepts. But I still think it is important for the court to have in mind, what the investment is as a matter of the treaty and then to ask the question, is there direct
Well, the treaty
application?
says an investment is the asset. The asset may start off as cash, and forgive me, that was why I was referring to 146, that illustrates the point, that it recognises that the initial investment, that you may have initially capital, but we know that that will probably become something else.
Yes.
Capital won't just sit, you won't just invest your capital, it will probably become shares or some other form of investment. And I don't see no problem with that at all. But I think what is more difficult is, for the overall purposes of this, is reviewing the investment in the broader sense, in the context of looking at what's directly applicable, as simply the piece of paper that you get, and not more substantively what that piece of paper represents, which is your investment in a company, such that things done to the company can affect your investment. It affects the return of your investment. It affects the return on your investment. In any normal commercial sense, you talk about investing in a company above and beyond just simply the piece of paper you get.
My Lord, I'm fully on board the force of your point. It's important to point out that in a usual case, there is a possibility of claiming for the diminution in value of your shares caused by action on the assets of the company. So, treaties, generally speaking, allow for diminution of value of the share claims. The point on this case is that Article 1.8 is very exceptional wording. You don't see it in any other treaty, and we do see it, and Mr. Dahl will come back to this point this afternoon. We do see it in this BIT, which is made at a time when India is revisiting its BIT program, because it is very concerned about having just lost a case in white industry. And therefore, yes, the test in Article 1.8 may be unusually stringent, but we say that follows on from the ordinary meaning of the words, applying the usual rules.
You say, do you, that in investment treaties generally, you can claim for diminution in the value of your shares for reflexive loss, but that Article 1.8 is contracting out of that principle. Is that essentially your point on this, or perhaps Mr. Dahl will answer that this afternoon?
I think Mr. Dahl will answer that, but it depends very much on the terms of the treaty.
Is that what this all really comes down to? Does this treaty exclude the right to claim for the diminution in the value of your shares? Or loss of your share, value of your shares?
In a sense, obviously what it's requiring on our case is direct application to the investment. And if the investment is assets held by a local company in which you have no ownership or controlling interest, well, that cannot be treated as action directly applied to the shares. It's just something different. So I suspect that, in essence, it does come down to your question, but I don't want to tread on toes
It's
on.
quite, the number of executive actions which are going to directly affect shares will be pretty limited, won't it?
My lord, that's the importance of stepping back and thinking, here we have exceptional treaty wording, and this is not the usual case of an open offer to arbitrate. It's up to parties, treaty parties, to confine the extent of jurisdiction as they would like to, and you've seen that from the passage from EAIB in the tribunal presided over by Sir Christopher Greenwood. So it's not so much a question of whether it's unusual or not. It's a question of what did the parties agree with respect to jurisdiction, as they were entirely entitled to agree.
So your answer to my lord essentially then is yes, the direct application to the shares may be very limited, but that's not a problem because we mustn't assume that there will be jurisdiction to deal with every kind of problem in an investor-state arbitration, and we've always got state-to-state arbitration in the background.
That was the only other but that I was going to add to that, yes.
I mean, I suppose another thought is that occurs to me is that we are, of course, dealing with a case about shares here, but 1.8 isn't only about shares, it's about all sorts of other ways in which investments might be held, and you can see that from the definition of assets in the treaty. So it could be held by any number of structures. So there may be a danger in, this is the facts of this case, but there may be a danger in supposing that the drafters had specifically in mind the question of shares when they came up with this phrase, applied directly to an investment.
My lord, it's undoubtedly the case, and you've already seen that from the list of examples, that shares is only one of very many possible forms of investment. And if in this case, RAKIA had elected to make its investment in the form of rights under the BSA, then there would be absolutely no problem here. It simply elected to make its investment through minority shareholding in ANRAK. So therefore, we say correctly, the focus has to be on that investment.
But rights under a bauxite supply agreement in itself is meaningless. What value would that be to an investor?
Well, that's quite a difficult question to answer in the abstract. But what, for example, the investor might have done is to ensure that it directly or indirectly owned the local company so that it could fit itself within the line of cases that RAKIA is referring to, where it would be able to say invested by includes assets held by a locally owned subsidiary, and therefore the BSA is, I mean, it's difficult so far as concerns specifically rights under the BSA, I agree, because of the treaty wording of 1.3, which identifies that the relevant investment by would be the rights of performance under the relevant contract.
I'm not sure I fully understand this point about minority and majority shareholders at the moment, because let's just assume that Indian law is the same as English law here, which I think is how the tribunal saw it. A majority shareholder, as a matter of law, of municipal law, doesn't own the assets of the company any more than a minority one does. Might just about be different if it's 100%, because you might get into different questions there of alter ego and things. But supposing you had a 60%, they had a 60% shareholding here. Or let's go up a bit, let's say they had a 75% shareholding, which normally gives de facto control over all forms of resolution and so on. Still, the assets would not, as a matter of law, be treated as the assets of the company. So the repeated refrain that it's a minority shareholding, I'm not sure really adds anything.
My lord, it adds to the extent that RAKIA relies on a series of cases which show that where there is ownership or control, direct or indirect, then that would be sufficient for the purposes of investment of the relevant asset. And I'll take you to some of the cases in a moment. Maybe I'll do it right away. So you can see the tribunal's approach, or the differing tribunals' approaches. Some of the cases which we refer to in our skeleton say that the assets of the company are simply the assets of the company, and they are entirely legally distinct from the shares. We've referred you to cases like STAD and Bulgaria. Other cases which RAKIA relies on turn on what we called a control theory, where it is sufficient for there to be control. And you can see why tribunals might reach that conclusion, because they might say, yes, there has to be an asset, but the test is asset invested by an investor. So they may take the view that asset invested by an investor, the control of that asset is sufficient to justify that being treated as your investment, even though you don't own it. Can I take you then to some of those cases?
Are there any of those, just before we get there, in any of those cases, does this theory work if it's less than 100%?
The cases that RAKIA relies on, it focuses, you'll have seen, on EAIB, Diani, Siemens and Azurix. They are all 100% ownership cases. I believe that some of the cases it refers to in its footnote are less than 100%. I mean, if I can just turn to that, could I make, my lords, I've already taken you to Article 1.1 of the treaty. You see my point on it being an asset-based definition. If I could just take you to 2 points of context with respect to what we say an asset invested by must be. And the first of these, Article 4.4, at page 142 of the call. And you see that the second sentence of that, each contracting party shall, in accordance with its applicable laws and regulations, ensure to investors of the other contracting party the right of access to its courts of justice, administrative tribunals and agencies, and all other bodies and so on, for the purpose of assertion of claims and the enforcement of rights with respect to their investments. So we say that supports the understanding that when it comes to an investment, the investor will hold relevant rights with respect to that investment.
That's against any third party, isn't it?
My lord, of course it is, yes. Yes, it is. But it's envisaging that the investor will hold relevant rights. And we'd say, and you have this point, of course, that under the BSA, RAKIA has no relevant rights. And then Article 7.3, on page 145, where contracting party expropriates the assets of a company which is incorporated or constituted under its applicable law in force in any part of its own territory, and in which investors of the other contracting party own shares, stocks, debentures or other rights of interest, it shall ensure that the provisions of clause 1 of this article are applied to the extent necessary to ensure fair and equitable compensation in respect of their investment to such investors of other contracting party who are owners of such rights or interest. So we say that that is showing a difference between the assets of the local company, in which the shareholder has shares, and the actual investment, which is the shares.
So what happens in those circumstances? The assets of the company are expropriated, but although there is an obligation to ensure fair and equitable compensation, that is not an obligation which can be enforced by arbitration at the suit of the investor.
Quite right.
Is that your case?
That is our case, my lord. Just so you can see, and we're coming back to Article 7.3 in a lot more detail this afternoon in the context of the issues of measure applied directly to.
So you say your case is the whole of Article 7 is outside the arbitration scope, is it?
No, my lord, no. I'm just answering the specific question my lordship was making about Article 7.3.
But Article 7 applies to direct or indirect measures.
My lord, yes.
How does that square with 1.8?
It does square. My friend is going to be, my learned friend is going to be dealing with that this afternoon, with your leave. So also on context, RAKIA relies on Article 3.2, that's page 141. Contracting parties shall encourage and facilitate the formation and establishment of appropriate legal entities by investors in order to establish, develop and execute investment projects in different economic sectors as may be permitted by the laws and regulations of the host state. We don't really see what this adds, and don't see how the reference to investment project supports a case that assets invested by, in the investment definition, includes the assets of a local entity that the investor neither owns nor controls. All this is doing is encouraging the setting up of local companies for the purposes of an investment project. It is not turning the whole project into the relevant investment, that is the asset invested by the investor. Look, can I then take you to RAKIA's case at paragraph 15, which is core 6, page 62. And you see there what it's trying to do is to really divide up the formula, every kind of asset invested by the investor, into two pretty much non-communicating wholes. 15.1, assets must function as an investment to be protected. The words invested by the investor are as important to every kind of asset. Invested by has a broader meaning than owned by. Invested by is functional, signifying the use of assets to a particular end. See EAIB in Slovakia, and you see the quote there: the tribunal is not persuaded that the BIT requires that the investor be the direct owner of the asset. Article 1.1 makes no reference to ownership, rather it stipulates that the term investment shall mean all assets which an investor of one contracting party invests in the territory of the other contracting party in accordance with its legislation. This is broad language which is quite wide enough to encompass what is today the very common situation of a foreign company making an investment through a subsidiary incorporated in the host state. But when one turns to the EAIB case, which is at Authorities Volume 1, tab 12, and here the basic facts are that the investor, EAIB, holds 100% shareholding in a local subsidiary, EIC, which in turn holds the relevant investment, which is a 51% shareholding in a Slovak health provider called Apollo. So turning to paragraph 321, which RAKIA is relying on, that's at page 148. See there the passage that has been quoted by RAKIA, and then looking over onto 149, in the usage which was common in relation to investment by the time the BIT was concluded, an investor of State A which acquired control of a shareholding in a company incorporated in State B would be described as investing in the territory of State B, irrespective of whether it had purchased the shares in its own name or arranged that they be purchased by a locally incorporated subsidiary whose decision-making it controlled. In the present case, there is no doubt that Uram Bank controlled the decisions made by EIC, which was its 100% owned subsidiary. So this is making clear that the tribunal's reasoning is predicated on the control of the local subsidiary as opposed to any functional test as put forward by RAKIA. There's no suggestion here that having a minority shareholding of just 12% would be sufficient in order to find that there was an asset invested by the relevant investor. You can see from 321 at the beginning, the relevant investment definition stipulates that the term investment shall mean all assets which an investor of one contracting party invests in the territory of the other contracting party in accordance with its legislation. So that's obviously not in the passive tense. It's not an invested by, but essentially it's active tense, and it appears to be going in the same direction. So we say, and we accept in our skeleton, that ownership could be direct or potentially indirect, depending on the specific wording. And you already have our point that when it comes to the specific wording dealing with rights under contract, that appears to envisage that the relevant investor will actually hold the rights to performance. So in that context, indirect ownership might appear difficult. But in any event, the cases that RAKIA is relying on are all about control,
and this seems to be about a slightly different sort of situation, it seems to me, where, which is very common in groups of companies, where you have 100% subsidiaries owned by a company, which then in turn owns an asset. And in many contexts, one just says, well, it means the top company indirectly owns the shares in the lower company. And that's, I think, what this case is about. That's rather different from the question we're facing, which is where you've got a trading company with shareholders, and the question is whether or at least one question seems to be whether the shareholders can be treated as owners of the assets. It just seems a different sort of situation to me.
Well, my lord, potentially yes, but isn't it coming down to the same thing? Isn't there some form of direct or indirect ownership or control of the relevant asset? I take it, I see that here it is shares. If I can take you to the next case that is being relied on by RAKIA, which is the Dayani case, which is volume 3, tab 44. And if at 903 you can see from the head note, this is perhaps more analogous to the current situation. An Iranian company incorporated a separate company in Singapore for the purposes of acquiring a Korean electronics company, the largest shareholder of which was an asset management company that was majority owned by the Korean government. The Singaporean company entered into a share purchase agreement with the sellers and paid a substantial contractual deposit. When the acquisition subsequently fell through, the sellers complained that their deposit was forfeited. And you can see at paragraph 11 on page 907, this is referring to the incorporation, and before Mr. Justice Butcher there was no dispute that the Dionis owned and controlled this company, D&A. And then you see at paragraph 32, 913, the definition of investment in that case. The term investment refers to every kind of property or asset, and in particular, though not exclusively, including the following invested by the investors of one contracting party in the territory of the other contracting party. So it's the same invested by language. Then you see at paragraph 56, there's a rejection by Mr. Justice Butcher with respect to the third category of property or asset relied on by the Dionis and what they have described as the totality of their operations and in connection with the Republic. This is a reference to the matters specified in para 200 of the award. Unfortunately, that's not on the record. It's not in the public domain, actually. Insofar as these matters are not embraced within the two categories already considered, the SPA and the contract deposits, I was unconvinced that they amounted to anything which could properly and ordinarily be described as an asset or property. So we would say that's an entirely correct rejection, even in the case of a 100% ownership, of treating the wider project as the investment. Then overleaf at just above para 57 is a debate about whether purported investment has to have characteristics of an investment. And the Republic's second argument there, that even if the SPA and the contract deposit constitute property or assets, they nevertheless do not constitute an investment, because an investment must have certain objective characteristics, namely, one, a contribution to investment risk as opposed to merely contractual risk, and three, duration. And it's in that context, paragraph 60, that's the paragraph that RAKIA is relying on, concerned with inherent characteristics. Given the breadth of the definition of investment and given that the contracting parties could have not stated that investments should have certain characteristics, I do not consider that a requirement of such characteristics can be said to be added by the use of the words invested by, given that the verb to invest must be taken to have a similarly broad meaning to the product of investing, namely investments. So he's not considering at all the question of whether the term invested by could be satisfied where there is not direct or indirect ownership or control. He's just saying that the term invested by doesn't bring with it a requirement of inherent characteristics. Then at paragraph 68, he moves on to a separate question, page 920. Do the Dianis have standing under Articles 1.1 and 1.2 of the BIT to claim in respect of the SPA the contract deposit and other claimed investments defined in questions 1 to 3 above? And then you can see at paragraph 76, his answer to that, having looked at the Barcelona traction and other cases, what this analysis points towards is that the relevant question is whether the BIT itself confers a wide enough protection such that a shareholder may be protected in relation to damage to the assets of the company in which the shares are held. I consider that it does. The shareholders, at least if they exercise control over the company, as there was no issue that the Dianis did in the case of D&A, can, in accordance with the ordinary meaning and understanding of the words, be termed investors in the assets of the company in such circumstances, and the assets of the company can fairly be described as invested by those shareholders. The terms of the BIT are in this respect very wide, and you can see that he then refers to the von Petzold case, which is another case where the investor owned and controlled the relevant assets. You can see that at page 924, two-thirds of the way down. At paras 326, 327, the tribunal found that the von Petzold claimant's ownership and control of the Zimbabwean properties and related assets through an indirect corporate holding structure presents no bar to their claims for restitution and or compensation for the loss suffered to those investments. Further recognition that claims may be made under bilateral investment treaties if in wide enough terms by shareholders who control a company in respect of the assets of the company is provided by the arbitration awards in Azurex, which is another 100% ownership case that RAKIA relies on, and then it refers to various other cases. So, and you can see those cases, in particular Azurex and Siemens at paragraph 18 of the skeleton argument of RAKIA. And again, it's the same basic point. the tribunals are finding that in a case of 100% ownership and control, then the assets of the local company can be considered as part of the investment. If I can just show you Azurix, I don't think I've got any need to take you to, because you've already seen Butcher, Mr. Justice Butcher, making the point that that was all about the control, and in fact in that case the treaty language expressly referred to assets owned or controlled by the investor. And Siemens, which is being put forward to you by RAKIA as being the leading case, and it refers in its footnote 8 to various cases that have consistently cited it, and it's being cited for the proposition that the treaty does not require that there be no interposed companies between the investment and the ultimate owner of the company. Now, that is not addressing our case, which accepts that direct ownership is not in all terms required by this treaty, although it is required in that, or it appears to be required in the case of a contract because of Article 113 of the treaty, which envisages that the asset invested by is actual rights to performance. Siemens is at Authorities Volume 1, tab 28, page 358 is the relevant passage. And the basic facts are that Siemens held shares in a local company called Siemens IT Services through a wholly owned subsidiary called Siemens Nixdorf. You can see that from paragraphs 23 to the 24 of the decision, which I don't think I need to take you to, won't be in dispute. That's Authorities Volume 4, tab 65, page 1417. And 137 is what is being relied on. The tribunal observes that there is no explicit reference to direct or indirect investment as such in the treaty. The definition of investment is very broad, and investment is any kind of asset considered to be such under the law of the contracting party where the investment has been made. The specific categories of investment included in the definition are included as examples, rather than with the purpose of excluding those not listed. One of the categories consists of shares, rights of participation in companies, and other types of participation in companies. the plain meaning of this provision is that shares held by a German shareholder that are protected under the treaty does not require that there be no interposed companies between the investment and the ultimate owner of the company. So again, this is completely different to the current situation. And the principle that these cases support is that where the foreign investor owns or at least controls the locally incorporated company, then dependent obviously and always on the treaty wording, those assets may be considered part of the investment of the investor. They're not support for any wider proposition that the words assets invested by in a BIT include assets that are neither owned nor controlled by the foreign investor. And that's the proposition which RAKIA needs to succeed on in its case that the BSA is part of the investment.
The point that's being made in these cases seems to be a territoriality point, essentially, isn't it? That these are all cases, it seems, where there's a local intermediate shareholding company, and therefore the respondent says, "Oh, it's not an investment by someone from a foreign contracting state. It's a local investment, so it's nothing to do with this treaty." And the answer that seems to be given in these cases is, no, there is a foreign investor because it's just held indirectly through an intermediate holding company. That seems to be the issue which keeps on arising in these cases.
Well, my lord, in a sense, yes, although in certain cases the local company, the intermediate company is actually incorporated within the relevant host state.
Well, that's the point I'm making.
Yes.
That's exactly
not just
what I'm saying to you.
I do apologise.
So that because the intermediate company is within the host state, the answer given by the respondent in these cases is to say, well, it's not an international treaty case at all, because it's just a case involving a local investor complaining about something which has happened within the host state. And the answer that's given in these cases is no, if it's a local subsidiary which is just inserted as an intermediate holding company, the foreign investor which owns the shares in that company can be regarded as the investor. It's just an indirect investor.
But, my lord, I don't think it makes any difference to the principle in these cases where that intermediate subsidiary is incorporated. It could be incorporated in a third state. What matters is there a direct or indirect link of ownership or control to what is being put forward as the underlying investment. So if the underlying investment is said to be shares in a local subsidiary, the question being asked, I think, by all these cases is, well, can that be regarded as your investment, regardless of the fact that your actual investment is shares directly in some other company? Answer, no, doesn't matter. And that intermediary company could be incorporated somewhere else. As we see it, that would make no difference at all to the relevant principle. It's all about ownership and control of the underlying asset, which is said to be the investment. What these, I mean, in any event, what these cases do not support is the case that's being put forward by RAKIA, which is that somehow the assets of the locally incorporated subsidiary in this case can be regarded as part of the investment, as there's no ownership or control. My Lord, we also rely on a series of cases which focus very much, which say when you're looking at the question of the investment, you have to be focused in on what is the relevant asset. And to that effect, we're referring to Swissborough and Emis and Venezuela Holdings, paragraph 29 of our skeleton. And you'll recall that passage from the transcript that I took you to earlier. This is the basic point that Mr. Landau was accepting on RAKIA's behalf, that the relevant asset has to exist in domestic law. International law is about the protection of domestic law property rights. And in this case, of course, the legal attributes of the assets of ANRAK, including its rights under the BSA, are as defined by Indian law. And those attributes are not just relevant when you're saying, is there an asset or not? Because you have to be asking compendiously the question, is there an asset invested by RAKIA or not? What you can't do, which is what RAKIA seeks to do, is say, is there an asset? Yes, there is an asset under the BSA because the BSA gives contractual rights to someone. Then take a long pause of breath and say, was that invested by RAKIA? Well, yes, because you have to take a functional approach to what is meant by invested by, so that brings with it the entirety of the project assets. We say wrong approach when you're looking at assets invested by. You're looking at what is the legal asset, here contractual rights, owned by someone else. Can that be said to be an asset invested by RAKIA? No. We say that's not a natural reading of assets invested by an investor. And whereas a matter of the domestic law, the contractual rights accrue only to ANRAK, it makes no sense to see those as somehow invested by RAKIA, as it has no rights of any kind with respect to the relevant asset. But on RAKIA's case, every asset owned by ANRAK is part of RAKIA's investment. So that be the refinery, whatever cash there might be in the current account, the rights and obligations under the BSA, and any other asset owned by ANRAK, even though acquired through borrowing by ANRAK or cash injection by other shareholders. The question must be asked whether, absent express treaty language, the treaty parties would have intended to extend the concept of investment that far in circumstances where the investor has no rights of ownership or control, direct or indirect, with respect to those assets. So on RAKIA's theory, the treaty parties would be incurring international law obligations, specifically with respect to those companies' assets as opposed to its shareholding, with respect to an unlimited pool of minority investors. In this case, there happens to be just one minority investor, which is RAKIA. But in other cases, there might be dozens or hundreds of minority investors. For example, if a UAE investment company invested in a very large Indian company, something from the Reliance Group, which had been established to set up a particular project, we say it would be a very surprising result if the investment of those investors were anything other than its shares in Reliance. And one can see, as an example of that, if one goes to the FET provision at Article 5.1, which is in 414, page 142, this is standard fair and equitable treatment provision. Each contracting party shall at all times ensure investments made in its territory by investors of the other contracting party fair and equitable treatment. So on RAKIA's case, every time there is fair and unfair and inequitable treatment to any individual asset of the project company, then that is unfair and inequitable treatment to its investment, because that is part of its investment. You see how that's different to a diminution of value of shares claim. In the usual case, the investment would be the shares, and the investor would be claiming for unfair and inequitable treatment with respect to the diminution in value of its shares. But that's not RAKIA's case here. Its case is that the actual assets of the local company, any interference with those assets, is an interference with its own assets. Hello, can I take you quickly to the Swissborough case, just to show the focus on assets, how important that is correctly regarded as being. That's in volume 3 of the authorities, and that's tab 47. And if I can ask you to turn to paragraph 97, which is at page 1017. Now, the key issue in this case was whether an alleged right under a multilateral treaty to refer a claim to an international court, the SADC Tribunal, Southern African Development Corporation Tribunal, was an investment protected under the treaty. And you can see in 97, the court is identifying the importance of finding what exactly the relevant investment is. You see the definition of investment there, familiar asset-based investment there, referring to purchase, acquisition or establishment of investments rather than invested by. I don't think that's relevant for the point I'm seeking to make. Paragraph 103 the existence and scope of rights or property purportedly comprising an investment are issues that are governed by domestic law and not international law. In this regard, the following observations in Douglas are instructive. Investment disputes are about investments. Investments are about property, and property is about specific rights over tangibles and intangibles, cognizable by the municipal law of the host state. General international law contains no substantive rules of property law, nor do investment treaties purport to lay down rules for acquiring rights in rem over tangibles and intangibles. Whenever there is a dispute about the scope of the property rights comprising the investment, or to whom such rights belong, there must be a reference to municipal law of property. Insofar as investment treaties require a territorial nexus between the investment and one of the contracting state parties, the property law is the municipal law of the state in which the claimant alleges that it has investment. Indeed, this is a case where territorial nexus had a particular importance. Then you can see at paragraph 104, a similar point is being made in Newcomb and Paradell. The effect that general international law does not purport to regulate the complex nature of proprietary and contractual rights or the legal nature of state measures, and then referring to how the relevant rights arise in the context of legal relationships governed by domestic law. The point is well reflected in the corpus of investment treaty cases, reference to EMIS, which is a tribunal chaired by Professor Campbell, KC. In order to determine whether an investor claimant holds property or assets capable of constituting an investment, it is necessary in the first place to refer to host state law. Public international law does not create property rights, rather it accords certain protections to property rights created according to municipal law. Same point in Abasa, same point in Venezuela Holdings, you say tribunal chaired by Sir Franklin Berman. An investment is of its very nature an item of property. Property is not a quantity that is or can be created by international law. The only role of international law is to recognise property created and defined by national law, and then to draw from that whatever consequences may flow on the international plane. And then overleaf at paragraph 109, the foregoing analysis may be summarised in these propositions. When the investor makes an investment in the host state, it acquires property and or rights that exist or are conferred as a matter of the domestic law of the host state. The precise extent and scope of those rights are to be determined as a matter of the domestic law of the host state. As a matter of international law, the host state undertakes certain obligations and may be liable if those domestic law rights, including any property rights within its jurisdiction, are violated. And the final point is a territorial nexus point. So we say that any alleged assets of RAKIA said to be invested by RAKIA cannot be looked at in isolation from the relevant domestic law. A key question is who can possess and exercise the relevant rights. And that question then feeds into the question of whether it is an asset invested by an investor. And as I've said, I've made the point already, RAKIA is not pointing you to a case that suggests that the words invested by bring within them contractual rights that are not directly or indirectly owned or controlled by the foreign investor. And we say that that is not the meaning of those words, applying the usual rules of treaty interpretation. And while one can understand the logic of saying that someone who controls an asset via a corporate chain can claim in respect of that asset, where that is not the position, why should someone be able to claim? And what are the limits if they're not through some form of ownership or control? On what logical basis should a minority investor like RAKIA be able to claim as its investment, not just its shares, but say the $1 billion refinery owned by ANRAK and built very largely through the equity injections of the Indian shareholder, PENA, and loans from Indian banks? My Lord, if I could deal very quickly with 2 points raised by RAKIA before the short adjournment. Skeleton paragraph 17, RAKIA says that India's interpretation of the formula assets invested by an investor is an ownership fallacy built around an incorrect application of the Barcelona traction case, which it says is relevant only to diplomatic protection cases. And I've already taken you through our case on interpretation of assets invested by an investor, which is based on the ordinary meaning of the words in their context. Object and purpose doesn't add anything here, because the preamble just refers to investment, capital I, doesn't tell you what the investment is. On the Barcelona traction case, India relies on that for the limited proposition that customary international law recognises the separate legal personality of a company as distinct from its shareholders, and that the default position is that where a local subsidiary holds title to assets, those belong and remain the property of the local company, not the shareholder. That's the point we make at paragraph 31 of our skeleton, and it would be surprising if that basic proposition were in dispute. It is a matter for every given BIT then to define what an investment is, whether that requires direct ownership of assets or is satisfied by indirect ownership or control. Then on the Memorandum of Understanding, RAKIA also relies on this at paragraph 34 of its skeleton. Its key argument is at paragraph 34.3 and 34.4. That's tab 6, page 71. BSA was the detailed collaboration agreement provided for in clause 11 of the MOU. It gives effect to the government's promise of exclusive supply by APMDC to bauxite. In terms of Article 1.1 of the BIT, BSA was a successor in form to a promise made by India to RAKIA in the MOU of an exclusive supply of bauxite to a project company. That company was incorporated, and the contract giving effect to that promise was entered into as contemplated. The BSA is therefore an asset, and there's a reference to their evidence of the long-standing and foundational promise of entitlement to bauxite. Three short points. First, such promises as the MOU may have contained do not form part of RAKIA's investment, and both the Tribunal and Mr. Justice Knowles rejected that argument. Second, as is clear from clause 2 of the MOU, which I showed you earlier, the MOU contemplated that RAKIA's investment would be in the form of shares in the project company, which became ANRAK, and not rights under the BSA. And just as a matter of clarification, there was never any unqualified right to bauxite supply under the MOU. The construction and operation of the mine was always subject to APMDC obtaining the relevant forest and environmental clearances. Third, as noted by the Tribunal, the MOU appears to have envisaged that RAKIA would be taking the lead so far as concerns the $2 billion capital outlay for the project. At award paragraph 63, the Tribunal says the recitals to the MOU might give the impression that RAKIA, with its vast industrial experience as a highly competent and financially sound entrepreneur, was proposing to take the lead in investing $2 billion and bringing the best energy efficient and best aluminium technology available in the world to Andhra Pradesh. And of course its capital outlay was only 42.5 million. RAKIA could of course have made a much larger investment such that it would have been in a position to control ANRAK and to argue that rights in the BSA were assets invested by it on that basis. But of course it didn't do so. My Lord, thank you very much.
Right. Does that conclude what you want to say, or are you continuing after?
My Lord, no, I think that concludes what I wish to say. I'll just double check that over the lunch break.
Very good. Thank you very much then. 2 o'clock.
More table.